Sure. Good morning, everyone, and welcome to this webinar on recent business mergers and consolidation versus antitrust. A lot of mergers in the news. HDFC Bank with HDFC Limited creating a mammoth structure. PVR Inox, because I'm from entertainment business, we saw that many of such mergers which are happening, where you may not find it very good on the threshold part of it, which is 1,000 crore the criteria to go for CCI approvals. Most of the reasons may be because of the pandemic, the business revenue, etc. accounting has been less, and therefore you are out of that domain. But today we are here to discuss many other mergers, etc., which has happened with our panelists, and what will be the impact on antitrust or the competition, and whether there can be a suo motu cognizance, or what's the condition which will rely in future where it relates to competition law and the compliance from a market perspective. Dr. Bishwa Das is with me. It's a pleasure to be here, sir. I hand over to you, proceedings to you for introduction of the panelist. Thank you.
Thank you so much, Jamisa. A very good morning to all of you. I, on behalf of the Kids School of Law, Lay Witness, as well as the Society for Corporate Legal Studies, is welcoming you all to this panel. And today we have with us to discuss on this aspect of the mergers and the antitrust. We have with us Mr. G.R. Bhatia, who shall be delivering the keynote address to us. Mr. Bhatia is a partner with the Luthra and Luthra's Competition Law Practices Group. He was the former Additional Director General of the Competition Commission of India and the erstwhile Monopolies and Restrictive Trade Practices Commission. He has also been associated with the various amendments that has been made into the Competition Act of 2007. And it would be a sheer privilege to listen to G.R. Bhatia, sir. Along with sir, we also have Madam Aishwarya Bhati, Additional Solicitor General of India and Senior Advocate, Supreme Court of India. With her professional standing of more than 2 decades at the bar, she was appointed as the Additional Solicitor General of India in June 2020 and designated as a Senior Advocate to the Supreme Court in March 2019, and was also an advocate on record with an illustration of 2 decades of practice. We'll also be having Mr. Abhishek Malhotra, the managing partner of TMT Law Practices. Mr. Malhotra is the founding partner of TMT Law Practices, and he was 2 decades of experience as a member of both state bars of California, USA, and Delhi. His primary areas of expertise holds in commercial dispute resolution and subject areas of technology, media, and communications. We also have Mr. Kunal Nanavati, the managing partner of Nanavati Associates, Gujarat. Sir holds expertise in the area of taxation, constitution, excise and custom laws, and company law matters. He have represented organizations like Reliance, GNFC, etc. in his experience of more than 2 decades. We also have none other than Mr. Zamir Nathani, who shall be the moderator of this session, who is the Senior Vice President and General Counsel of Hero for Movies India Limited. Mr. Nathani is also the Chairman of Entertainment and Media at Indian National Bar Association. In his past career, he held the position of Head Legal as Balaji Telefilms Limited and the Head Legal as Balaji Motion Pictures Limited, a subsidiary of Balaji Telefilms Limited, and the Director Legal of Raymonds Limited, and also a professor at the University of Mumbai. Now, with this illustrious people along with us, we are looking forward to have a enriching session on the contemporary issue. But before I hand over the podium to Mr. Zamir Nathani for take it over, I would be requesting the Director of Kids School of Law, Dr. Bhavani Prasad Panda, to welcome you all to this August gathering and to Kids School of Law. Please, sir.
Thank you, Professor Vishnu. I'm very happy this August program is happening with the galaxy of the speakers over here. I welcome all the people, all the esteemed speakers, and Professor Bhatia, Professor Mr. Kunal Nanavati, Jamir, Aishwarya, and others. I'm here only to greet you from Kids School of Law. It's a August occasion for us. this such a important program is happening. But let me tell you about few words about the Kids School of Law. Kids School of Law established in the year 2007, and since then we have been working hard. Today we are standing at the 10th at the NIRF, and with the School of Eminence also. And that way, Kids School and Kids University are only one part of it. The other part of it is a big, uh, it is called as Culling and Social Sciences, where around 30,000 tribal children are studying over here for pro bono, and right from the kindergarten and up to the PG, PhD, and everything. And they have been under one roof, and it is seeing is a believing over here as far the institute is concerned. And I welcome you. This is unfortunately we are not able to call you over physically, but we'll be definitely happy to see you physically sometime if you are really free. And I'll be requesting our Professor Bispo to contact you and see that if you can really come and uh, visit our campus and address our students. Our students would love to interact with you people directly rather than in the virtual mode. We have all limitations, and the limitations of only one way listening and getting the things. But however, we're really honored and privileged by your kind participation in this particular program. I welcome you wholeheartedly, and I look forward to hear from you all people. I will not take much time because your time is valuable, and every moment we will be looking and we will be hearing to you. Thank you, Professor Vishnu Kalyan.
Thank you, sir. Without further ado, I will be handing over the podium to Mr. Jamil Nathani.
Thank
Please,
you.
sir.
Thank you very much. And thank you for your kind words, sir. We are now proceeding to the program. Just before we start speaking on the recent business mergers and consolidation versus competition or antitrust and the impact on it, all the speakers who have been invited, Ms. Aishwarya Bhati, Additional Solicitor General of India and Senior Advocate, Supreme Court of India, Mr. G.R. Bhatia, ex-Additional Director General, Competition Commission of India and presently partner and head of competition law with Luthra and Luthra. Mr. Kunal Nanavati, Managing Partner, Nanavati and Associates, and Mr. Abhishek Malhotra, Managing Partner, TMT Law. I really want to thank you from the bottom of my heart, because I know especially Ms. Aishwarya Bhati and Mr. Bhatia are continuously engaged in such works of research. Especially Ms. Bhati is engaged with the Government of India, and she's continuously busy, and for taking out time for this program. I'm really grateful. Okay. Now, from the topic perspective, just let me give you a highlight of what of the mergers took place and what are we looking at. All right. Pandemic situation, the revenues were down, and therefore there is a threshold of CCI of 1,000 crores. If you don't pass that particular threshold, then you don't require a CCI approval for the merger which you are proposing to have. All right. Some of the examples which I can give you, some may have gone to CCI, some may have not gone to CCI. Various reasons would have been there. But because of the pandemic situation, revenues of the companies were down, but mergers were still happening. And these are the examples you have. The first example you have is Reliance Industries with Edwards Technologies, where 54% stake was taken by Reliance. HCL Technologies and German IT firm, which is Jesselkraft, GMP, 51% stake was taken. Infosys had taken ODT, a German digital marketing. Axis Bank and Citibank retails business were merged. Tech Mahindra and Thirdware, which is a Mumbai-based enterprise application startup, it's about 42 billion in valuation. Then we had recent examples of HDFC Bank and HDFC Limited, Z Entertainment and Sony India, Tata Sons, Air India, Tata Digital and Big Basket, Byju's and Akash Educational Services, Wipro Limited and British Consulting Capco, Tata Digital and Pharmaceutical Startup 1mg, HDFC Life and Exide Life, Piramil Group and Diwan Housing, Adani Green Energy and B Energy, Farm Easy and Thyrocare. So these are live examples in front of you where we are discussing. And of course, from my entertainment perspective is PVR and Inox was presently in the news also for the prospective merger which is happening. These are the scenarios where you see mergers which are happening. What will be the impact on the competition? And if they don't meet the threshold of the CCI of the 1,000 crore, whether CCI will take a suo motu cognizance of it, or whether this will be a strict interpretation of law, because the law is meant to be interpreted strictly, and therefore, these mergers will be part and parcel of the market, and gradually the competition will grow accordingly. That's the sum and substance of the debate and the discussions we have. Once again, a privilege to have such elite speakers. My first question, which I will ask, is to Dr. Bhatia, that as an opening remark, because you are also an ex-additional Director General CCI, what was the thought process at that time? Because this must not be in this scenario also. This would have happened little while back also, when financial crises were there in 2008, etc. What could be the thought process of CCI looking at the market perspective of this having an adverse impact on the competition? Mr. Bhatia, your opening remarks.
Sir, you have to unmute.
Yes, combination is one of the most important limb of competition regime. And we thought that it is our experience, it was experienced that when you are not able to meet and compete with a competitor, the next possible solution in your mind is to go for marriage. So corporate marriages are indispensable so far as you see, for survival and thriving is concerned. So it's nothing new. It's nothing new. In fact, when Mughals noticed that it is very difficult to beat and compete with Rajputs, Mughals thought of marrying in the family of Rajputs. So is the case in the corporate sector. So and so that's why combination provisions were introduced, and it is in line with the global trend. So like what provision exists in US or in other mature jurisdictions, almost on the same lines. But yes, there are few escape walls and few loopholes are there. So we have got combination provisions, but major distinction between anti-competitive agreement and abuse of dominance and combination is that both ACA and AOD, they are enforced ex post. After the loss has been caused, generally, then the CCI comes up with an inquiry, investigation takes place, parties are punished, and then in case the aggrieved persons can demonstrate before the appellate tribunal that I have suffered loss, so there is a provision for award of compensation. But so far as combination is concerned, they are not per se bad, they are not objected to, they are not prohibited, they are only regulated. So these competition commission act as a gatekeeper. Because it is generally believed that combination do bring synergy, and combination is a need of the time. And of late, sir, you might have noticed that the number of mergers, as you yourself have mentioned, has considerably gone up. This is partly because of the after effects of pandemic. So we are right now going through a phase of volatility, uncertainty, complexity, and ambiguity. And hence, for my survival and to go ahead to thrive, I have got no other possible solution but to consolidate, but to go ahead with mergers, amalgamation, or acquisition. Having said all these things, as I now see that you have mentioned two cases, HDFC as well as this PVR, yes, there is a loophole in our system that unlike in the FTC of US or in Germany, there is a provision that CCI that the regulator can call for details of any merger, notwithstanding whether it has crossed the threshold or not. Unlike those jurisdictions, sir, we don't have a provision. Only certain combinations, which the aggregate value of assets or turnover of the parties, in case it exceeds the limits prescribed in the Act, then, sir, it is required to be notifiable to the competition regulator. If the merger or amalgamation or acquisition is below those thresholds, then it is not required to be notified. And then I'm not vested, CCI is not vested with suo motu power to call for details of the proposed combinations. And this is certainly an escape wall. This is certainly a gap which need to be filled up. Otherwise, such type of mergers will continue. And the major loss to society is that it is said that, okay, you post merger, the entity will continue to be governed and governed by the provision of anti-competitive agreement and abuse of dominance. But that is ex post enforcement. That means after the loss is caused to the society, to the consumers, to the intermediaries, thereafter corrective action can be taken under that. So I think in case we want to bring a total halt to a loss to society without having the effect on competition, we need to fill up these gaps. Another about, you have mentioned about HDFC case also. You know, there are three filtrations under our competition law. One, that there is a de minimis threshold, which says that in case, that is a notification issued by central government, that in case the target entity doesn't have more than 350 crores of assets or 1000 crores of turnover, then you are a small entity. By marrying that, by acquiring that entity, by merging with that entity, it is expected that appreciable adverse effect will not be there, because I'm acquiring or merging a small entity, not expected to have appreciable adverse effect, and hence it is exempted from notification. PVR case seems to fall in that category. Then there is a case of HDFC Bank and HDFC Limited. And, you know, apart from de minimis, the Competition Commission has issued combination regulations. To those combination regulations, there is Schedule 1, which carves out certain categories of transactions which are not expected to have appreciable adverse effect, and they are also not required to be notified. So that's CCI own doing. And so as per that notification, as per entry 8, in case there is reorganization within the same group, then such transaction is not required to be reported to CCI. As I see, as per media report, HDFC Bank and HDFC Limited seems to be a wholly owned subsidiary of HDFC Bank. If that be so, then it will be able to avail of the benefit of exemption under entry 8 of Schedule 1 of the combination regulations, and may not be required to be reported to CCI. So these are, yes, and unfortunately, based on the Competition Law Review Committee, in the proposed competition amendment bill, there is a provision which empowers that central government can modify or can adopt any other criteria for notification of a combination. I think that is not going to serve the purpose. In US, there is another third criteria apart from assets and turnover: transaction value. If the transaction value, if the size of the transaction is of a particular level, the transaction necessarily need to be reported. But instead of size of transaction, we have, in our amendment bill, we have introduced a provision that the central government should be vested with a power to notify any criteria which it feels it appropriate. I think it is a dilution of the power, and it's likely to be misused. So perhaps it is not going to serve the purpose. So hence we need to give a suo motu power like, as you know, in respect of anti-competitive and abuse of dominance, there is a suo motu power with the CCI. Nobody has filed complaint against WhatsApp, but WhatsApp, it came up with a modified privacy policy, and Competition Commission at its own, without having any information or complaint, thought that here is a case which seems to be a classic case of abuse of dominance by WhatsApp messaging service provider. And it has initiated investigation. And despite the fact that WhatsApp has tried its level best to get scuttled the investigation, but Delhi High Court has both single bench and division bench has not allowed, and so investigation is on. So unlike suo motu power, there in respect of anti-competitive agreement and AOD, which Competition Commission is blessed with, I think so far as combination is concerned, suo motu power should also vest in the CCI to call for details of any combination which Commission feels that prima facie it seems to be anti-competitive.
Okay. All right.
Any other aspect which you feel I have missed out?
No, I think you have taken a 360-degree tour for CCI for us on the perspective of whether CCI can take cognizance on that. And from an industry perspective, what I saw in PVR was also the synergy part of it, what you saw, and the reach which they are looking out for. Otherwise, the access to the cinema halls, in the other parts of the country will not be accessible unless there is a synergy and a tie-up between them. So we have seen from a synergy and reach perspective how the deal will make a difference. But there is also a view, Aishwarya ji, if I can bring you now, on the green channel filing. The green channel filing, which was recently introduced by the learned CCI for the purpose of expediting the process of confirming or approving the combination application under Section 5 of the Competition Commission of India Act, is a first of its kind trust-based system where notifiable transactions having no overlaps are approved upon filing, which is suo motu without any physical inspection, provided all the ingredients of for forming a competitive agreements are fulfilled. Now, in the light of this recent combination that have been approved by default, by virtue of not being violative of any provisions of the Competition Act, the question is, if this green channel filing an effective tool for fast tracking the process, or is it becoming a liability by way of approving combinations with set criteria with a complete disregard to potentially abusive criteria? What is your view on this?
Thank you, Zamirji. In fact, I must start by telling you that it is really gainful for me to be part of such valuable discussions because, having practicing in the highest court, I don't get too much exposure to such nuanced areas and just have that, that top of the pyramid view of some of these things. So it is very, very useful and gainful for me to hear stalwarts like Bhatia Saab, who are at helm of affairs, and I'm sure I'll get benefited from other colleagues, distinguished colleagues. So thank you very much for having me here. I'm happy to be here as a student of law. Now, I think this green channel, though it may be something new for the Competition Act, this is a norm in business practices. Green channel is something that we know most commonly from the customs green channel than that that we walk into when we are coming from abroad. The whole point, I think, it's a very pro-business stand. I think it makes the atmosphere more conducive, trust-based. Yes, everything is based on a self-assessment, a self-declaration. So absolutely, these are business houses that that we are dealing with, Zamirji. So why do we need to start looking at them with suspicion if there is no reason? See, that is why those conditions are also there, that you have to meet those yardsticks. Then there is self-assessment, self-certification. You fill in those, and you are taken. And then, so one aspect is the green channel. The point is, can somebody get away with abusing the green channel? Now, there are enough safeguards that are available in the Act currently And even at the introduction of this green channel, there is enough safeguard that is available to my mind. I'm not really a practitioner of this law at the Competition Act, as I'm just a student. So to my mind, I think enough safeguards appear to be available for people who are violating the conditions or the norms of the green channel. There is some misdeclaration or mistake by them in the assessment, etc. And of course, the suo motu powers combined with the suo motu powers which are available otherwise to the competition tribunal. And you can't get away from Competition Act is one very important pillar of the business and the corporate, the commercial litigation. But the point is that there is a existing in a very robust criminal mechanism that is in place. So it's not like, WhatsApp and Facebook, they got their due diligence and certifications and everything from a US regulator, which we all consider to be a much more mature, developed systems who are working more efficiently. But there are now concerns about reopening and re-looking at the kind of the merger, the kind of consolidation or merger the WhatsApp and Facebook had. So I don't think we need to worry about, of course, these Competition Act is one area that keeps on developing very fast because the way businesses are developing, the regulator has to keep pace, and the regulator has to ensure that they are not becoming a roadblock, a stumbling point for businesses. At the same time, ensuring that they act as a true regulator, they have the right kind of systems in place to allow best practices or the business practices which are genuine business practices to pass through these creation of so-called green channels with sufficient embargoes available for them to be checked back. So to my mind, in theory, again, as a student, again, my discussion, my line of it would be only a very theoretical point. And also, we've also seen that this is a very evolving area of law. So if more things come to light, manners in which this is sought to be misused, then I'm sure the regulator and the government will step in and plug those loopholes wherever required.
Absolutely, I agree with you. And we have seen in the past that even CCI has gone to an extent of making a statement that when the WhatsApp case happened and WhatsApp gave an argument saying that this is about data privacy, CCI is not the right regulator. They went to the extent of making a statement saying that there is no sector specific regulator, and therefore we need to find out whether this will have an appreciable adverse impact on the competition. Because the focus of CCI always remains that whether there is a monopoly or abuse of dominance position by an entity, whether there is a cartelization between two entities or more than that, and whether there is a tie-in agreement which may have an appreciable adverse impact on the competition. And we have seen on and off that CCI is going beyond the scope to find out what it may have an impact on the market. We have seen examples of Amazon, we have seen examples of WhatsApp, etc. So I think rightfully they are getting into it just from a market perspective because it may look very nice as a deal, but what it could have an impact on the market competition is always at the forefront of it. My next question is to Kunal. While we were discussing on these aspects, though the PVR Inox merger may have not been part of being under the Competition Act, it surely has a potential cause, what we may say, is one side of the interpretation which came from the market. From our perspective, it was a synergy and it would increase the reach. But from perspective which came from other side of the market is that there is a potentiality of that the market of multiplexes and the entertainment industry may have only two names which can be cited. How can this merger ex ante affect the other players in the market, the consumer, and most importantly, the movie producers? This is from that perspective when it came. Kunal, your views on that?
Yeah, so thank you. It's a pleasure being here. I'm a bit like fish out of water amongst the solvers here, but I'll attempt to make that answer as much as possible, as lucid as possible. I think as far as the merger is concerned, yes, what you said is correct, that it makes the largest entity insofar as multiplexes is concerned. I believe there was also an occasion a couple of years ago where the multiplexes unified and decided not to show some movie. I don't remember the name of the movie offhand, but that's a scenario that is like could replay, given the fact that they become one of the largest multiplexes that's becoming an industry by itself. They can potentially dominate. They can potentially also say that this is the movie, or this is the movie that we won't publish or display. They could potentially also determine the prices of the tickets as well. So it may or may not work both ways. Of course, consolidation is important. It also brings in the additional comforts that a consumer can go to a PVR is much better than a standalone cinema hall. The kind of luxuries that you enjoy in such kind of multiplexes obviously worth the price. And that comparison, the weighing of the cost versus benefit is something that I believe is an active investigation or an active development that the government possibly, and anybody who's interested, any party who's interested, can obviously check over a period of time and counter by making whatever complaints that the act, of course, has that provision, has the power to do so. So I think that's a check and balance is there, and a consolidation at the same time is important given the history of COVID and what toll that it took on various industries, not only this. So.
Right. So I think from a competition perspective, because I'm part and parcel of this industry,
true.
It's divided between a producer, the distributor, then the exhibitor, which is your PVR, Inox, and other cinemas. Producer is the most person who's the decision maker that, I want to have access to this particular theater and all that. And this keeps on balancing between the two.
Right.
But surely what happens is that, the operating cost of the cinema and access to it has still remained difficult. So, that's why this cat and mouse race sometimes happens. But point is that there are certain commercials which are more important. So, in this business, there is a virtual print fee, which is now decided by the CCI as a chargeable fee. There was a case which was filed against PVR, Inox, and others. And the CCI gave a judgment in favor of PVR, Inox, and others. We were part of that also, where they said that the virtual print fee, which is charged, is a genuine amount which is chargeable, because those are expenditures which were also there when the earlier technology. So earlier there was real technology, now it is digital technology. And the price have actually reduced by 4 times. So because of the digitization. But there were cases which came up before CCI on those points which you're speaking about. And CCI so far on the point of EPF has given a favorable order. From a market access point of view, there is still a problem of reach. Without discussing much, just have a comparison of the theaters, because we are on the entertainment industry. So even the government of India has now taken an initiative. There are 60,000 theaters which are available in China, but in India, it's about 10,000. And the reach of our audience is far more. So to increase that particular reach, you will require such synergies. You will require some initiatives. You will require initiatives. Even government of India is very interested in doing so, because they want to have a reach for the audience who are not able to access cinemas. So there are people who now travel 10 kilometers to just go to a cinema hall with the family, which is like a picnic for them, So that's the kind of things, and where I think some of the industry players will have an important role. Once you increase the reach, even when Akshay Kumar was asked about this, see, when you increase the reach about it, then your pricing, etc., will all come under consideration, because your commercials will then also match with the numbers. So that was one of the things which was going in mind. Let's see how it comes up. Uh,
Thank you.
my next question is to Mr. G.R. Bhatia. Sir, when we speak about CCI's suo motu powers, what is the significance of CCI's suo motu powers to initiate inquiry and the future of a complaint with a specific emphasis on recent mergers and combinations which you see? Sir.
Yes, I think suo motu power is unique and extremely important for a competition regime. As I mentioned, there are several courts which don't have suo motu power. And so there has been several reasons why the regulator has been conferred with this power, suo motu power. So there are many reasons. Many a times I'm not able to muster strength to file an information with the Competition Commission. Many a times I want that my identity ought not be disclosed to the other side. Many a times I am not in possession of sufficient evidence to demonstrate that my case is eligible to be considered prima facie as anti-competitive or abuse of dominance. Many a times I am not able to give the fee which is required to be given along with the information. So there can be several reasons. For example, I am a practicing lawyer and learned ASG is available, is on the panel. Can I file a complaint against Bar Council of India? I am a small lawyer. I can't muster strength if in case there are any abusive conduct. So with a view to meet such type of exigencies, and also many times because competition aspects are ever evolving, the in the wisdom of government and in line with the global trend, competition regulator has been blessed with suo motu powers, and incidentally 20% of the inquiries which are initiated which have been initiated by the CCI, they belong to suo motu category. But then there are certain pitfalls when an inquiry is initiated suo motu. One pitfall is that when we go to the court, the other side challenge the initiation of investigation by the CCI, because court will ask, where is an aggrieved person? Who is the aggrieved person? Who is the complainant? Who is suffering on account of this anti-competitive or abusive conduct? So this is somewhat which need to be taken care of. Barring this, I think suo motu is a good power. It has been widely invoked and exercised by the competition regulator, and there have been good result of the suo motu power. Incidentally, I may also mention that the proceeding before the Competition Commission are proceedings in REM and not in personnel. So even if I am not an aggrieved person, I can initiate inquiry, I can file an information with the CCI. So from that perspective also, I think suo motu power also becomes important.
From a suo motu perspective, I think what we have been seeing CCI of late, examples of Amazon case, examples of WhatsApp case, I think there is a cognizance, there is an eye of CCI, which is always there on the matter. Abhishek Malhotra has joined us. Abhishek, welcome. We knew there was some personal difficulty, and thank you very much for joining us.
Thank you so much, Zamir, and I apologize to the panelists for being absent all this while. But in today's times, I think vaccinations takes precedence over anything else, and unfortunately, today was the only slot that we got for my younger child. So I'm really sorry for this.
Right, no problem. Post your vaccination, we want some dose on the CCI also. So, we gave examples of various mergers, acquisitions which were happening. We know HDFC Limited, PVR, then there was Tata and 1MG, etc., which happened. Since you cater to the entertainment industry, and we had some discussion on that from Kunal also. Your question was basically that the PVR and Inox has escaped the threshold of the deal, breaching the threshold for compulsory filing with the CCI. Can this proposed combination can still be questioned? And if yes, under what circumstances? Because they are in line with the law. So under what circumstances do you feel, even if this comes up, how could CCI take cognizance?
So, as we all know, Zamir, that one of the thresholds for creating an issue in the competition law scenario is in the event that there is an appreciable adverse effect on competition, right? So, independent of whether or not the threshold, of the merged entity in terms of cumulative revenues, etc., is breached, if the CCI is of the view that this is likely to result in an AEEC situation, they can suo motu, issue show cause. The provision is silent on as to whether or not that exercise of jurisdiction can be pursuant to an information received in this regard. But I mean, it's not prohibited. So it could be that the precursor to commencement of such an independent inquiry by the CCI could be triggered by, let's say, an information or material that is available that it is likely to cause in that sort of an impact. I don't know whether, since I've joined late, I don't know whether the discussion that had already taken place did bring into play the earlier merger of PVR and DT Cinemas. No. Because at that point in time, so this is an interesting aspect because a similar situation had actually come about. And if I'm not mistaken, it was sometime in 2015 or so that this particular consideration was brought before the CCI. And as I recollect, the CCI went into this aspect of what is referred to as the Herfindahl-Hirschman Index, the HHI, to consider what would be the market concentration pre and post the combination, and looked at the, there is a, because this is more of an economics principle, the index that was used. I'm unfortunately not going to be able to go into the details of that because I'm a lawyer and I should not trample into the economist's domain. But essentially, the figures that are used in that sort of scenario are, if the HHI results in a number which is higher than 2000, then it is considered as a highly concentrated market post-merger. If it is between 1,000 and 200,000, then it is considered a moderately concentrated. And so if they looked at, so in the highly concentrated market, if post-merger, the HHI increase is 150 or more, and in a moderately concentrated market, if that increase is 250 or more, then there is a presumption that it would be resulting in an AEEC, appreciable adverse effect on competition. And in coming to those conclusions, at least in that context, what the CCI did go into was aspects as, other independent competitors in the market, and what would be their availability post the combination, what would be the impact on pricing of tickets, what are the benefits, of course, arising out of the merger, then what are the incentives that are creative, what are the possible barriers to entry in the market. So all of those aspects, the degree of countervailing power. So in this case, let's assume that there is a merged entity of the exhibitors. As we all know, that the market for films in India, of course, in the digitized version and post the pandemic, perhaps we will see a market shift towards OTT platforms, and that's not something that's really been taken into consideration when the PVR-DT merger was being looked at. But in that scenario, on the one hand, you have these multiplex screens, which are the preferred destinations for people more and more to go and watch films. And of course, you have distributors in the middle, and this is in the manner in which the market is created. You have distributors according to territories. And then, of course, you have the producers. Now, are the producers, do they as a group have the countervailing power to be able to offset this possible AEEC? All those questions, of course, are gone. So there is this, some time ago, there was this issue raised by by this company owned by Ronnie Screwvala, which had raised an issue with regard to these theaters charging a VPF. Yes, exactly. I'm sure, Zamir, you're much more of an expert on this aspect. But so I'm saying these are all of these issues that are likely to be taken into consideration in the event that the CCI was to look at this in a suo motu scenario. Yeah.
Okay. Thanks, Abhishek. I think what we were discussing on this particular merger, which is happening, proposed to be, I think you have just added more value to it by saying that there has been in the past, there has been some similar type of scenarios. I think those are the guardrails which have to be kept in mind while this proposed merger is being proposed. My next question would be to Ms. Aishwarya Bhati. The competition law, now we have discussed about, first we have figured out that what are the types of mergers which have happened, the quantum, the examples. We saw some 15 mergers which have happened in various industries. There are some cases which have not gone to CCI, some have qualified, some have not qualified for the threshold. We have seen the green channel discussion which you led, and we have seen Mr. Bhatia also discussing about the combination and what are the scenarios where suo motu actions can be taken by CCI. Whereas we have examples of WhatsApp and Amazon also, where CCI was proactive in the matter because it may have an adversarial impact on the competition. The Competition Act 2002 has provision to deal with anti-competitive agreements and or abuse of dominance. How can these laws be applied to an agreement which per se may not be anti-competitive, but under a veil has been entered into with an object to monopolize the market? And it's a fantastic question which has been put. One of the examples which came before Amazon also was that, whatever product sells much on Amazon, later on you will find Amazon also making those products in its own brand name. And there are companies which were there, which were handling those affairs of Amazon. And by virtue of that, Amazon also came into question on what's the impact on the market it is having. So your question with an example, your views.
So Zamirji, that is why, this branch of law excites me so much, despite not having too much practice here, being confined to the Supreme Court. I don't get to experience this much, but it's so exciting. The case that we were discussing about, the WhatsApp case. Now the whole facade that was put up was that it's a privacy issue. Competition Commission has nothing to do with it. So you keep your hands off because this is beyond your scope. And I mentioned briefly that Facebook WhatsApp order, that's also something that's very, very, I found it very exciting, that a merger that took place years back, Facebook took over WhatsApp, Instagram, etc. And last year, a similar suit was brought before the District Court of Columbia in the US. And it was thrown out but it was thrown out not on the basis of a principle, but on the basis of a finding that there was not sufficient evidence that was available to go into this aspect. Then, a comprehensive research was done, all statistic data points, everything was brought before the court. And this time, I think, if I'm not mistaken, in January of this year, the District Court Columbia, the same judge incidentally, opens up this debate. And now it has gone to a parameter that where the product is free, now to my mind, this is going into a very much more nuanced field, that where the product is free, then also can the regulator go into the aspect of monopoly in the form of whether the customers are getting lesser of the service, or they are at the raw deal in any which way, where the customer is not paying for the service at all. So I think it's very exciting. I don't think we need to worry about the company's law has enough provisions, enough judgments of Supreme Court interpreting the lifting of the corporate veil. To my mind, there should be no problem. Our own commission has shown it that they are not going to get bogged down by these facades that are put up as veils, that they don't fall into the regime of the Competition Act. The movement across the world in the more mature jurisdictions appear to be that. So good business practices, great. But then if you are falling foul of the regulator, then the regulator will question you. And then we will keep on evolving, Zamirji.
And one of the examples of what you just spoke about was on the earlier trends where the services were free. And therefore, if you see the terms and conditions of the website, now we are using app, terms and conditions, privacy policy, cookie policy, where cookie policy says that we can use your data for marketing purpose, etc., etc. You know, these were said to be considerations for getting those free services, and you have ticked on those checkbox. So those were the questions. But today, when you see Competition Commission, especially in India, it is taking a cognizance where people are going beyond scope. So now today, when you have your privacy policy, when you have your cookie policy also, while the Privacy Act is still to come into force on personal data and sensitive data, but I think the argument which WhatsApp put across saying that, you know, you are not the regulator as CCI to get into this domain because it's a privacy issue, where the CCI stepped in and they also boldly make a statement saying that, you know, there is no sector specific regulator and CCI actually has got a domain to go across and also find out whether there is an adverse impact on the competition, and therefore rightfully we have gone into it. So I think those are the kinds of agreements what WhatsApp also had as a policy, because those are all your agreements on for using the app. Those are also then within the domain of CCI when CCI feels that, you know, they have a scope to get into it. But yes, have any views on that?
Yeah, I think you are both Aishwarya and both of you are right. But as I see, as of law, as the law now provides, creation of monopoly, acquisition of dominance is not per se bad. I may be dominant, and incidentally, let me tell you that there are several advantages of having a dominant player in an industry. Why I am dominant? Why Google is dominant? Because they are investing heavily in R&D, because they have been taking care of their customers, because they have been they have been involved deeply in innovation. So dominant, and then they have got the capacity and ability to lead an industry. So invariably, that's why so far as cartel is concerned, they are perceived to be flagrant, blatant violation of competition law. But so long the issue remains only up to acquisition of dominance. Dominance per se is not bad, but once I am intoxicated with dominance, then if I am indulging in abusive driving, abusive conduct, then law gets triggered and then law gets attracted. So if I am a dominant player, I am expected to observe all rules of the game, all rules of the traffic norms, but I always, as a dominant player, I owe a special responsibility in case I am indulging in any of the conduct which falls in section 4.2. That means unfair pricing, unfair terms and conditions, predatory pricing. That means selling below the cost of production with the intention to eliminate a competitor. Or if I am having differential terms and conditions, then only section 4 abuse of it becomes a case of abuse of power. So mere dominance is not bad. Rather, it should be welcome because of some inherent advantage which flow from a dominant player, as I see.
I think you're right. And but you know, there was a judgment of Bharti Airtel also where some specific statement was made, or where it was Harshita Chawla versus WhatsApp. You know, the CCI also noted that users are not provided with appropriate granular voluntary choice to object or rather opt out of the data sharing, unlike the 2016 WhatsApp privacy policy update. You know, that's why it came into question. And it was then observed that it would be very unfair and unreasonable condition to the user to accept the update to essentially conclude the contract, saying that, you know, either you accept it, take it or leave it. So that is how CCI report concluded, saying that, you know, it said that the policy would amount to take it or leave it, which would then amount to an abuse of dominant position and prima facie violation of section 4.2 of the act. So this was one of the positions and the stand which was taken by CCI. I think
So
we are in the realm of debate, but I think
Samir,
CCI
you are
is looking from a
absolutely right.
perspective
Samir,
of
you are
market.
absolutely right. But
Yes.
here is a question of conduct.
Yes.
Yeah. So it is conduct which is objectionable. So once again, we come to practice, not dominance. Dominance is on account of that they have got 40 million subscribers, people who are making use of it. So you have got huge clout. But having this much clout is not bad. But if you are now, because of your dominant power, now you are abusing it. And at my back, you are changing the privacy policy. Then, sir, here comes the question of conduct, which falls within the purview of Section 4 of the Act.
Right. Kunal, when you see horizontal mergers which are happening, like the discussions we are having, what is your view on these horizontal mergers, which may be basically juxtaposing the legislative intent of the competition law in an oligopolistic market? So what impact it would have on the legislative intent of the competition law when these mergers are happening?
I believe Mr. Bhatia has touched that issue slightly. It all depends upon the intent. Forget the capability. It's about how you use that capability, and I think that is inherent in everything that in everything, every person, every company, juristic or otherwise, every person. So whether or not you may be dominant depending upon the area in which you practice. You may be dominant depending upon the area in which you practice. So regardless of whether you affect the entire nation, the entire world, the entire state or a city or an area, where it's all relative insofar as how you exercise that dominance. Whether I believe there was a couple of years ago, Google had this motto, "Do no evil." That was kind of Google's motto, because obviously the information that they would have on everyone is almost all pervasive, and I think that's no secret by now. And we voluntarily give this information because we need to use the convenience of Google, so to speak. So simply them having it is one thing, the amount of data, but what they would do with it is an entirely different scenario. So and just as Mr. Bhatia has already said, the dominant position by itself is not bad. The abuse of it is bad. So that therein is an answer to that question that you posed.
Right. And some examples like on the privacy side also. So here the CCI has been cognizant. They have been on the matters. There are a lot of things which are written in the press. They are taking suo motu cognizance. They're getting into it. They're getting into market research, which I can tell you. But from a privacy perspective, Facebook and Cambridge Analytica,
Correct.
where Facebook shared about 87 million details of the users with Cambridge Analytica, so that Cambridge Analytica would evaluate your political choices. And
Right.
this was specifically used in United States 2016 in Donald Trump election.
Right.
Those are the kinds of impact which can have on data privacy. And
Correct.
therefore, when CCI looks from a market perspective,
Correct.
that what adverse impact it can have, that's the reach we are talking about. Next question is, but Abhishek, to you, when we are talking about these mergers, and like Mr. Bhatia pointed out rightfully, Ms. Aishwarya Bhati also said there has to be checks and balances, and Mr. Bhatia said these are synergies. There are going to be mergers which are happening because consolidation is also need of the hour. What is, from a strategy point of view, what is your recommendation or an advisable strategy for an informant to adopt while challenging those proposed mergers ex ante or ex post? So what's the advisable strategy? Because people are looking out for this particular impact on the market. We may not be cognizant of it, but the market players would be cognizant about it. What is the advisable strategy you would recommend to the informants while adopting to challenge those mergers?
So I think, Zamir, I'll just give an example of how that sort of ties in, but essentially, and this is in relation to a paper that I had recently collaborated with some people and written for the CCI. They have this annual competition and event where they call for papers. So we looked at the various ways of regulating or not regulating aspects of competition, and the strategies or the theories that are to be brought into play, specifically with regard to the digital economy, because that's where a bulk of the action is already taking place and it's headed. And we basically came to a conclusion that broadly there are 4 strategies, right? And I'm looking at it more from the point of view of the regulatory regime, and then I'll come to from an informant's point of view. So broadly, those 4 are either you go for forbearance, or you go for ex ante regulation or ex post regulation, or you go for deregulation, right? And the broadly, as I said, this is rule of thumb aspects, but specific facts may differ. Broadly, and this is also not just India, world over, when it is an emerging market, when something is in the nascent stages, typically speaking, the strategy adopted or should be adopted should be forbearance, because then you're allowing new technology, new ideas, and new business models to develop. So why should you stymie that growth by bringing in aspects of regulation, right? Whether it is competition or regulation or otherwise. The second is where there is an oligopolistic setup. There are, it's a fairly mature market, and it has sectoral regulators there. So like, let's say the telecom space or broadcasting space, etc. Telecom more so oligopolistic, broadcasting not so much oligopolistic. What do you implement then? It's a combination of a play of the sectoral regulators regulation as well as possibly the CCI coming in. And there, broadly, there is a shift and a tilt towards ex ante regulation. You want to regulate the behavior before it takes place, before it results in an anti-competitive situation. Then you have those markets where there is no sectoral regulator. The example that we were just discussing in the data protection space, there is no sectoral regulator. Should you rather adopt ex ante or ex post? Wait for possibly a problem in the market. I'm not saying wait for complete market failure, but wait and watch, keep a watch, see what's happening. Is it creating an issue? And then you decide to go in for ex post regulation. And when it's a completely mature market, whether there is a sectoral regulator or not, many players, there is a competitive setup, go for deregulation. That's the 4 broad strategies. Now, coming back to the earlier question which you had asked me, and in that context, let's assume that there is an informant which is an independent producer. They are not a biggie in the market, but it's an independent producer, and it fears that this merger between PVR and Inox is likely to create a further problem for them to be able to get an appropriate window to exploit their content across these big chains. And they're likely to be charged a higher commission than what is the market standard. They may be levied with other costs. They may not get an appropriate time of the day when they can show their film, etc. All those considerations. Should they adopt an ex ante approach and approach the CCI with an information while this is still not seen the light of day, while the thing is still in motion, and ask for a show cause notice to be issued? Or should they wait out and see how this plays out and then see the result? I think the answer to that question really, very frankly, is based upon what is the prevalent market practice. I mean, PVR is big enough in and of itself. Have there been instances where in and of itself PVR has adopted a strategy vis-a-vis smaller producers that does not allow them market access? Is there enough evidence for that? Has there been an impact on pricing of tickets? Has there been an impact on the show timings? Because all of that makes a lot of difference. If you don't get an appropriate show where more and more people come, we all know it's the first weekend and possibly the first 1.5 weeks where most of the money is made or recovered for the film. Is that window available to these people? So all those questions have to be answered on a basis of empirical data If that is available, by all means, go and try and seek an ex ante. If not available, wait and watch what is the impact and then go for ex post. So I think that's what my answer would be.
Right. And I agree with you. I think that's where the strategy will lie on how the informants take cognizance in any of the mergers. Before I go to my final question to Mr. G.R. Bhatia, some of the examples which I'll just repeat for the convenience of the audience is we had recent mergers like Axis Bank and Citibank Retail Services. We spoke about Tech Mahindra. We spoke about HDFC Limited and HDFC Bank. Z Entertainment and Sony India is in the realm. Tata Sons Air India, Tata Digital Big Basket, Tata Digital and again pharmaceutical startup 1MG, HDFC Life and Excite Life, Adani Green and B Energy, Farm Easy and Thyroid Care. So these are recent mergers which have happened. In the light of that, from your experience, vast experience, I would like to ask you, having an understanding of the de minimis criteria or the threshold for initiating an inquiry under the provisions of the Competition Act, in light of the mergers, what is the course of complaint filed against certain transactions that are not notifiable or reportable? What is your view on that, sir?
I think you have asked me the most difficult question. Yes, there is absolutely, you are right. Now, if this PVR or this HDFC Bank transaction is reported to CCI, then a summary of transaction is required to be displayed on the website of CCI, as well as it will be put on the website of the party concerned also. Right? So I, as a general public person, I can go through that summary, and in case I have got a grievance, then I can give information or complaint to CCI that this is my objection, which should be addressed by the CCI. If the transaction is not notifiable because of the filtration points which I mentioned, de minimis, schedule 1, and then substantive test, then in that case, there will be absolutely no summary on the website, which is also a case in case of green channel transactions. So if I have got an objection about some transaction which has taken place on green channel, I am being denied of that opportunity to raise my voice. So there is absolutely no mechanism to file any kind of protest or information or complaint against the proposed transaction in case the transaction is not notifiable.
Oh, okay. So these are two. So these are two requirements.
Yes. Apart.
Where basically.
Yes. Now in this now PVR transaction or HDF transaction. Now, as you were right in mentioning that some of the real estate owners who owns prime real estate who wants to lease out to Inox and PVR combined entity. So because of the countervailing power of this new company, new merged company, sir, the lessee will be the real estate owner may not get terms and conditions which are appropriate in the given market scenario. Similarly, film producers, they can be dictated terms and conditions because they are a dominant buyer, Inox plus PVR. Similarly, if I happen to be a cinema goer, for example, I'm a resident of Ambala, and in Ambala there are only cinema theaters which belong either to Inox or PVR. So that means complete lack of competition in Ambala geography. So I, as a cinema goer, if PVR and Inox combined entity put together, they say, now our food counter will charge you this much. I don't have an option. I don't have a choice, and I don't have a cinema house where I should go. So these are the pitfalls by having this loophole, that it's all right, abuse of dominance, I can file complaint and all those things, but why it is better that we should take remedial action well in time instead of taking post-mortem and post-active.
So I think these two criteria of wherever suggestions has been done by any person saying that, these are prospective mergers which are happening. I think this point is important that CCI has to give its findings or understanding on its website, and it has to be also consequently displayed on the website of the respective companies is something very important so that, the informant and the public at large can be aware that there was a cognizance taken and a finding or an understanding has been given for the present scenario. You've got too many questions which are lined up. I will not be able to take all the questions. There are some list of 21 questions I've got it, which will take us beyond lunch, and we don't have those facilities here. So I will just restrict myself to about one or two questions. Anyone from the panel can take it up, Suomoto. Mr. Bhatia, this is specifically for you. Can you throw light on Schedule 1 exemptions from CCI approval point of view? And one person has also asked me whether exemptions under Schedule 1 is, in your opinion, viable.
Difficult questions once again. Yes, exemptions have been provided. It is so motive that the Competition Commission itself have carved out certain categories of transaction which it feels that it is not likely to result in appreciable adverse effect on competition. One of the, for example, is reorganization within the group. You are already within the same group, within the same family, and hence this consolidation is not likely to enhance your market share, because when we talk about dominance, then we take market share of the group as a whole and not of a standalone basis of the enterprise only. So as a group, HDFC or HDFC Bank, their total strength is taken into account. So you are absolutely right, but yes, so this is one category. Similarly, suppose pursuant to a divestment order issued by Competition Commission, you are asked to acquire certain entity. You are one of the bidder. You have been accepted by the CCI. So if you are acquiring any asset pursuant to CCI directions, then it is also in the exempted category. You need not notify that transaction. If you are already having, if you are making just a small investment, which is less than 10% of the total capital of the target entity, then it is only for the purpose, if it is only for the purpose of investment, then this transaction also need not be reported, because you are making investment only for the purpose of dividend and you are not going to interfere in the control or management of the target entity. So it is also construed to be not having appreciable adverse effect on competition in the relevant market, and therefore it also stands exempt. So there are few categories, like kindly appreciate that in under section 3, if you are entering into agreement relating to goods or services, so if any agreement relating to goods or services is covered under section 3, any agreement relating to structural change is covered under combination. So this is the major distinction. So like suo motu power, how CCI can initiate suo motu power against PVR? It is a structural change. It does not fulfill the requirement of section 3 anti-competitive agreement, because the agreement doesn't relate to sale or purchase of goods or services. Rather, it relates to purchase or sale of some shares or assets or control. So suo motu power can't be exercised in relation to combinations.
One question we have is, once a combination has been accepted by CCI under the exemption criteria, but ultimately leads to appreciable adverse impact on the competition, how will the exemption be uplifted? Are there any examples, if any?
Sir, you are making me appellate.
we are charging you from a ex-DG perspective.
Yes, yes, you are absolutely
You can come a little closer to your mic if you can.
Yeah. Sir, kindly appreciate that even if the merger has been approved, later on the conduct of the merged entity is subject to the discipline of the CCI. In case that combined entity, merged entity enters into any kind of anti-competitive agreement, or its conduct is found to be abusive and it happens to be a dominant undertaking, so their practices are governed by Section 3, Section 4 of the Competition Act. So even if the combination has resulted in AEC, now later on the unscrambling of is not possible. They will continue to be a combined entity, but their conduct will be subject to the discipline of the Competition Commission. And that's why a prior ex ante approval is required, because you can have from egg you can make omelette, but once omelette has been made, you cannot bring it back to egg position, because third party interests etc. are created and it becomes very difficult. And that's what is going to be the major problem in green channel combinations. So I personally feel that it is more in the interest of party, as has happened in the case of Amazon. Now, if subsequently CCI comes up with an argument, Mr. Green Channel filer, you have given us wrong information. You are not fulfilling or satisfying the requirement of Green Channel, and now we suspend the approval which we have. In that eventuality, it will be a big problem for the Green Channel filer, how to bring back the combined organization. So it is going to be a big challenge. So
I think this kind of debate on this question also came when the Monsanto deal was happening. Whether prospectively this may have an impact, and I think Aishwarya ji also rightly pointed out, and one person has commented that Green Channel route actually is a set procedure, more like a digitized process, and there has to be a concentration of the application of mind, or otherwise it will become a loophole in the law, as you pointed out. And I think Aishwarya ji also pointed out that whether approving combinations by virtue of those Green Channel filing with set criteria may have a complete disregard to the potentially abusive criteria. I mean, it may go in that direction. It's on the presentation, what happens on day one, and what can have an impact at a future stage. I think
in fact, there's also an example in the Jet and Etihad case where the issue was related to a sale and leaseback arrangement between Jet and Etihad of 3 pairs of Heathrow airport slots, right? So they did not notify the transaction, saying that this is a commonplace, transaction as part of the industry, etc. CCI specifically did not agree to that, saying that the 3 pairs of Heathrow airport slots formed the entire basis of Jet's, the entire services between Delhi and India and London. So therefore, it is likely to cause a substantial business operation and impact on operation, and therefore it ought to have been notified. So these are instances where CCI is not, I think, a mute spectator, and certainly has the power to intervene.
I think CCI is taking cognizance, and rightfully it is getting into it. I mean, how the party would come and justify the same is there, so that at least the smell test, what we call, is normally passed off, so that CCI has taken cognizance, has undergone a study. Of course, it comes at a cost of making your submissions, etc. But the point is that CCI is taking cognizance of late at a high rate, but probably it may have an impact of getting it to the best of the markets. This is what we have from our end. Aishwarya ji, Kunal is there, Abhishek, Mr. G.R. Bhatia, thank you so much. I think what we discussed today is we gave you the examples of the recent business mergers which were happening versus the competition impact it may have. What are the various aspects where the CCI can get into it, or the Green Channel filing, or the various strategies which can be put forth, so that such particular mergers are from both sides, where the companies are merging it and where there is an informant who's a market player who sees that this may have an impact on the market, take cognizance of that. And lastly, we also gave you some inputs on what structural criteria can become a part of CCI taking cognizance of it. Last final example which was given was Jet Etihad, where even the 3 airport slots at the Heathrow Airport in London was substantially part of that particular deal. And therefore, CCI had intervened and said that this is critical part of the deal, where the CCI has to get into the domain to find out whether this deal is pro-market or it may be otherwise. This is all from our side. And thank you very much for all your questions. And thank you to the audience. Thank you to my learned speaker, Ms. Aishwarya Bhati, Mr. G.R. Bhatia, Mr. Abhishek Malhotra, and Mr. Kunal Nanavati. Bishwa, I hand over this to you. Thank you very much for inviting us.
Thank you so much, Jameer. And now I would be taking the podium to thank, on behalf of Kids School of Law, Lay Witness, as well as the Society for Corporate Legal Education, for having spared your time and coming over this platform and enlighten all the audiences about the various nuances that are coming up, both from the regulator's perspective as well as from the practitioner's perspective, with respect to the mergers and the antitrust regulations that we are having right now. I'm sure the audience have a lot to take away from this session, and there are a lot to introspect and do a further study and further research, and what we call as the food for thought from the session. And they will be dwelling further and taking it as a stepping stone for their understanding on these issues and developing their sound knowledge thereof. I would personally thank on behalf of Kids School of Law and all the organizations out here, to Mr. G.R. Bhatia, to Abhishek Malhotra sir, to Kunal Nanavati sir, Aishwarya ma'am, and of course, Jameer Nathani sir, for hosting this event so lucidly and engaging the whole session with all the questions and answers being posed for the audience. Thank you so much. And I wish you have a good day. And I would be soliciting your kind assistance and help and guiding our students in future as well for various such occasions. Thank you so much. Have a good day.
Thank you to Kids School of Law. Thank you, Lex Witness, Akshay Alag, CEO of the company, Bhupinder and Nilima, and Society for Corporate Legal Experts, Aditi Sharma. Thank you, everyone. Thank you so much to the speakers once again from the bottom of my heart for making today to this particular session. Thank you, everyone, and have a great day.
Thank you.
Thank you.
Thank you so much, everybody.